Hi, good day, ladies and gentlemen. Welcome to the first lesson, first topic, first discussion for the subject legal aspects for business. On your right, you see the book that we're going to use for the entire term. And then this book is available at WCC Graduate School, or you can order it online at Unlimited Publishing website. The first topic is entitled Nature and Sources of Business Law. The first question that comes into our mind when we hear legal aspect of business is what is business law? So when you say business law, it's body of rules, whether by convention, agreement, or international or national legislation, which governs the dealings between individuals and commercial matters. Also, business law refers to the broad field of law that governs the conduct, rights, and obligations of individuals and organizations engaged in commerce, trade, and sales. Also, business law prevents and resolves conflicts, and it has significant role in protecting consumers and the public. Next is the scope of business law. The scope is the contracts, sales agency, employment law, corporate law, taxation, consumer protection, intellectual property, environmental law, and international business law. I'm going to give you some example how the business law could apply in real life. Okay. The importance of business law are number one, protects business owner, consumers, and the public. Number two, ensures fair trade competition. And number three, provides legal framework for resolving disputes. Okay, I would like to explain the application of business law in real life by giving you one example. Say there are two friends named ABC and XXX. They love to go to Jolly B because their favorite food is chicken and joy. They know and confident to say that whenever they want to go to Jolly B, they get the same taste, the same quality of chicken and joy, no matter what time. Okay. Now, why is this possible? It's because of the business law. So, under the scope of business law is the contract. Now, there's a contract between the supplier and the establishment, Jollibee B. The contract stipulated the prices, the condition of the goods. There's an agreement to follow the food safety standards, the ethical labor practices, and the suppliers must adhere to their agreements or the products will be rejected, or there will be termination of contract, or there will be no more renewal of contract. So, the establishment were able to achieve the good quality of the product and services simply because of the contract. And contract is just one of those business law provide for the consumer like us. So remember, there's contracts, there's sales and agency, there's employment laws. Because of the business law, the establishments should adhere to the law under employment, the minimum wage, the number of leaves, their benefits, the number of hours, and the condition of their work. So those are under employment laws. Aside from that, if the establishment is under corporation, that it would be under corporate law. There's also taxation. There's consumer protection. There's intellectual property. There's environmental law. And if it reaches the other country, then the establishment should adhere to international business law. So that's how vast the business law really takes place and how it plays important part to every individual. We are now in the second part, the sources of business law. When you say sources of business law, it answers the question where the business law came from. Okay. Number one, of course, the Constitution. Constitution is the supreme law of the land and serves as the foundation for all other laws in the Philippines. It defines the structure of government, the rights of individuals, and the limits of governmental power. Next is the statutory law. This law enacted by legislative bodies like Congress and are specifically written to govern particular aspects of society, including businesses. It provides clear written rules. Example, Revised Corporation Code of the Philippines or RA 11232. Number three, administrative rules and regulations. It's issued by the government agencies to implement and enforce statutory laws. It creates specific guidelines to regulate industries, ensure consumer safety, and promote fair business practices. For example, Department of Trade and Industry or DTI, Securities and Exchange Commission or SEC, Bureau of Internal Revenue or BIR, or Department of Labor and Employment or DOLE. Next, number four is jurisprudence. Jurisprudence is legal principles that are established by Supreme Court decisions. Next, number five, customs and traditions. It's long established practices that over time have been recognized by the courts and the legal system as having the force of law. And lastly, international law. International law refers to treaties, conventions, and agreements that the Philippines has signed and ratified with other countries. Example, Philippines' participation in WTO obliges the country to follow international trade rules, reduce tariffs, and encourage fair competition. However, from the book Essentials of Business Law, 10th edition of McGraw-Hill from Wikes University, stated that executive orders, treaties, common law, precedent, and case law are also sources of business. Executive orders are legally binding directive issued by the president with the intent to change the manner in which agencies and officials operate so as to improve the practices of the government. Google gave three examples of executive orders in the Philippines. Okay, number one, the Executive Order Number 2, series of 2016, signed by the President Rodrigo Duterte. This operationalized the public's constitutional right to information by mandating full disclosure of transparency across all executive branch offices and agencies. Second example is Executive Order 59, Series of 2024, signed by President Ferdinand Marcos Jr. This order streamlined the permitting process for infrastructure flagship projects to accelerate the execution of the Build Better More program. Number three, Executive Order number 292, series of 1987, also known as Administrative Code of 1987. This order reorganized the entire executive branch and serves as the foundation for modern Philippine admin law. Now, second one are the treaties. Treaties are a written agreement between two or more countries that serves to establish terms of an international relationship. It could only be legally binding when they are approved by two-thirds of the Senate. As per the Lawfield Project, this first treaty show is the Mutual Defense Treaty. It is an international agreement in which signatory nations pledge to defend each other in the event of an armed attack. Most famously, in 1951, U.S. Philippine Mutual Defense Treaty and the 1953 U.S. South Korea Mutual Defense Treaty, obligate member nations to act together to meet common dangers according to their respective constitutional processes. Number three is the case law. Case law is the body of legal principles established by courts through their decisions in actual cases. Specifically, case law refers to the rulings of the Supreme Court of the Philippines that interprets the Constitution, statutes, and other legal rules. Example: Tan Andal versus Andal. The legal question: what standard should courts use to determine psychological incapacity as a ground for declaring a marriage void under Article 36 of the Family Code? This is normally used in the case of annulment. Well, we don't have divorce in the Philippines. Here in the States, we do have divorce. So the common reason that they use for annulment is psychological incapacity. So the question: what is psychological incapacity? The Supreme Court abandoned the old standard from Republic versus Molina 1997 and adopted a new, broader test. The old Molina test required the psychological incapacity be mental incapacity or personality disorder that must be proven through expert psychiatric testimony. The court in Tandal rejected the approach entirely. The practical effect. So before the Andal, a spouse seeking to nullify a marriage based on psychological incapacity had to present a psychiatrist or psychologist to testify that the other spouse had diagnosed to have a personality disorder. Normally, this is so expensive and so tedious. Many meritorious cases were dismissed because the petitioner could not afford the expert testimony. But after the Tanandal or the current law, expert psychiatric testimony is no longer required. The totality of evidence standard applies any credible evidence, including testimony from family members, friends, or co workers who observed the spouse's behavior before and during the marriage, can prove psychological incapacity. The incapacity must still be A. Rooted in the spouse's personal history, existing before or at the time of the marriage. Number two, grave, and C. Incurable. But this can now be shown through ordinary witnesses and circumstantial evidences. Why this is a good example of case law? First, it changed the existing rule. A doctrine followed for 24 years, or Molina, was expressly abandoned. Number two, it filled a gap in the statute. Articles 36 of the Family Code says a marriage contracted by any party who was psychologically incapacitated to comply with the essential marital obligations of marriage shall likewise be void, even if such incapacity becomes manifest only after its solemnization. The law does not define how to prove this incapacity. Case law supplies that standard. Number three, it applies to everyone. Any future nullity case in any Philippine court must follow Tanadal, not the Molina. Lower courts that ignore the new ruling risk reversal on appeal. Case law is not just a collection of past rulings, it is living law that evolves. Tanandal changed how thousands of future nullity cases will be litigated, making the remedy more accessible to ordinary spouses who could not afford expert psychiatric evidence. That is what case law does. It interprets, clarifies, and adapts the written law to real life circumstances. Number four, common law. Common law is a legal system primarily based on judicial decisions and precedent rather than written statutes originating in England. It relies on the doctrine of stare decisis, meaning courts follow the rulings of prior similar cases. Example: a patient goes to a hospital for a routine gallbladder operation. During surgery, the patient's bile duct is severed. The patient wakes up with severe complications requiring additional surgery and a prolonged hospital stay. The patient has no way of knowing exactly what the surgeon did wrong. The patient was unconscious during the procedure, and the surgical records are under the hospital's control. With res ipsa loquitur, or common law doctrine adopted by Philippine court, the patient can argue that the injury or severe bile duct during routine gallbladder surgery is a kind of inquiry that does not ordinarily occur in the absence of negligence. The burden then shifts to the hospital and surgeon to explain what happened and prove they were not negligent. Now, the key insight: the Philippines is a civil law country by origin, but American colonial influence brought common law methods of reasoning, particularly the use of precedent and the adoption of judge made doctrines. Philippine courts freely borrow common law doctrines when they fill gaps that the civil code or other statutes do not cover. This is what legal scholars call a mixed or hybrid legal system. Number five is precedent. Precedent is a court decision on which later courts rely in similar cases. Case law and precedent are two terms used interchangeably. But what's the difference? Precedent can be referred to a brick, while case law is the whole wall built from many bricks. Precedent is singular or specific case, and case law is plural. It is all the cases on a topic, including the precedent that started it, the cases that followed it, and only or any cases that modified or overturned it. Real life example: the death of Molina President. The President Republic versus Court of Appeals Molina, GR number 108 763, February 13, 1997. The single case established a specific rule: to prove psychological incapacity under Article 36 of the Family Code, a spouse must present expert medical or clinical evidence, essentially a psychiatrist diagnosis. Every court in the Philippines had to follow that rule because Molina was binding precedent or one case, one rule. The case law on Article 36. This is the entire collection of Supreme Court decisions interpreting psychological incapacity spanning from 1987 to today. It includes Santos versus Court of Appeals or 1995, first major case defining psychological incapacity. It must be grave and serious. Letter B. Republic versus Court of Appeals, 1997, established strict and 8-point guidelines requiring expert medical evidence. Or C. Chi Ching Chai versus Court of Appeals in 1998 refined Molina held that lengthy sexual refusal can be psychological incapacity. Until it reaches 2001, the Tanandal versus Andal, it abandoned completely the Molina case. It established a new totality of evidence standard. Now, precedent is the tool the Supreme Court uses to build case law. The court decides one case, or precedent. That case becomes binding on lower courts. The court decides another case, another precedent. Over time, these individual precedents accumulate. The accumulated body is what we call case law. When a lawyer says the case law on the issue is well settled, the lawyer means that multiple precedents have consistently ruled the same way over many years. When a lawyer says this is a case of first impressions, The lawyer means there is no precedent yet, and the court will create one. Real life application. The absolute majority. The 13 vote rule. Under the Philippine Constitution, a majority of all senators, 13 out of 24, is needed to officially elect the Senate President and constitute a quorum to conduct business. But with the Avellino versus Cuenca doctrine in the landmark of 1949 Supreme Court case Avellino versus Cuenca, the court established a precedent that alters this arithmetic. The court ruled that if some senators are outside the country and thus beyond the coercive jurisdiction of the Senate, under this precedent, the majority required is based on the number of senators present and available within the jurisdiction of the Senate. That ends the lesson one. Thank you very much for listening. Until then.